Even students of corporate law probably know generally what the Charles Dickens novel Bleak House is about. A lawsuit, Jarndyce and Jarndyce, that lasted for 40 years, consuming an entire estate in legal expenses. Students of corporate law also know about the case of Cede versus Technicolor, although they may not fully appreciate its similarities to the lawsuit in Bleak House. So, let's look at Cede versus Technicolor by the numbers. Duration of the litigation? Over 22 years, from 1983 to 2005. 2 trials, the first one lasting 47 days, the second 9 days, or 56 days in all. 6 appeals to the Delaware Supreme Court, 5 resulting in reversal. At stake, 201,200 shares. Merger price, $23 per share. Final valuation, $28.41 per share, for a net recovery of $5.41 per share. Total recovery, in addition to the merger price and without interest, about $1.1 million. Estimated legal fees and expenses, $20 million. The 2 Delaware lawyers at the forefront of the Technicolor litigation, Tom Allingham of Skadden, Arp, Slate, Marr & Flom, counsel for Technicolor, and Arthur Dent of Potter, Anderson & Caroon, counsel for the plaintiff, Cinerama, were just young lawyers when they got involved with the case.
So, Tom, how did you end up involved in this case?
I was afraid you'd ask me that. I came to Delaware at Morris Nichols because it was the only job offer I had coming out of law school as a function of my poor law school performance. And I was there for 6 years and then joined Skadden in late February of 1983. I was hired by a partner named Steve Rothschild. And I don't know, my 3rd or 4th day at Skadden, he walked into my office and said, well, you better start getting to work. Here's this case, Technicolor. I don't know very much about it. So it was my first case in Delaware as a Skadden lawyer.
So the merger took place, the facts giving rise to the merger took place in the fall of 1982. And it was the transaction closed and the merger closed in January of 1983, and I think the appraisal petition was filed sometime in the spring, if I remember. I started law school in 1983, and I graduated, took the bar in 1986, and started at the firm right after Labor Day. By that point, much of the discovery and events that we're going to talk about today had occurred. Gary Greenberg, from New York lawyer, had teamed up with Bob Payson and Peter Sigloff from my firm, and had been engaged in that discovery against Tom and his folks. So I started in the fall of 1986. In January, I think it was, January of 1987, so I was brand new. That's when I got involved. I remember Peter Sigloff coming to my office, I'm going to say January, early February, and asking me if I would like to get involved in this case. And that's how I got involved. This is now years after Tom had been involved, of course.
And so you started essentially as a first-year associate and lived the whole rest of the case through your career.
Yes, I started after the case had been around for 4 years and just stuck around with the next 20, for the 17 or 18 years after that.
Mr. Dent's co-counsel from New York, Gary Greenberg, led the case on the Cinerama side from the beginning. He exemplified the intensity of this long-simmering case in his dealings with the trial judge, Chancellor William T. Allen, and opposing counsel.
I also think that my sense was there was not a great dynamic between the Chancellor and Gary. I never really got the sense the Chancellor was all that fond of Gary. And Gary he could be off-putting at times, and I think he sort of got under the Chancellor's skin. And I don't think that helped us.
So we were talking, tell me the story of the last day of trial.
This is very Delaware. We finished the 47th day of trial, and I had promised Dave Margulies, who was the senior associate on the case, that he and his wife and my wife and I would go to dinner at the Silk Purse. I'd take them out to dinner, and we walked into the restaurant and sat down, and we were having a couple of cocktails, and the door opens, and in walked Gary Greenberg, Arthur Dent, Sylvia Shapiro, and Pete Seeloff. And they sat down at a table that was 10 feet away, which was maybe a little uncomfortable, but fine. But I think everyone was glad the trial was over and had a few cocktails, and Gary got up at some point and walked over to the table, and I introduced him to my wife and said, "This is Gary Greenberg you've heard so much about." And Gary looked at my then wife and said, "We all love Tom, even though he is a no-good lying son of a bitch." And you asked me, and I've never been sure whether that was a joke or not. It was a long trial.
On the other side, the man who engineered the acquisition of Technicolor by McAndrews and Forbes, Ronald Perlman, does not describe himself as a soft touch.
I am the world's most tenacious human being on the planet, and probably the most impatient, and like to get things done quickly and smartly, and very rarely reach the point of giving up. My first wife once said to me, "You kick a dead horse and tell it to get its ass up moving." And I think that one comment described me more accurately than anything else that I've ever heard about me.
Still, the case that Cinerama and its principals, James Cotter and Michael Foreman, initiated was hardly a full-scale attack. It was just an appraisal case, a simple dispute about value. And maybe not even much of a dispute about that.
Why did it start as an appraisal petition? Do you know how the case came to be the way it started?
My recollection is that Gary and Jim Cotter called Bob sometime reasonably close to the date of the shareholder meeting, which would have been late January. I don't think Bob was called until relatively close to the vote. So I don't know, looking at it cold back then, there was a sense that there was anything there other than a potential appraisal action. I do know that folks thought that the 1-hour photo sort of venture that Mort Kammerman had led the company into within the year before the transaction had a big impact on the price, depressed the price. And I think there was a sense that in an appraisal, the value of the company would be deemed to be significantly higher. I don't think then we had an inkling of potential liability.
From our perspective, though, there's the question of appraisal or liability case. There's also the question of why you would file an appraisal at all.
Right.
There was a cryptic handwritten note in the record, and I'm dredging this up from 20-something years ago. But which we believed, and there was someone on our side that I talked to about this. The note appeared to suggest that either Jim Cotter or Mike Foreman, the Cinerama guys, had told somebody on our side that they were happy with the price, but they wanted to get long-term capital gains, and that the only way they could do that was by filing an appraisal to delay the receipt of the proceeds.
Whatever Cinerama's motivation might have been for starting the litigation, the case didn't seem a likely target for asserting breach of fiduciary duty, as Chancellor Allen explained.
The important thing to remember about this case, well, almost nothing, but at the time, the important thing to remember about this case was it was an arm's length transaction. And it was accomplished prior to the date when Revlon was decided. No one had an incentive not to get the best price. And indeed, the CEO was an active, intelligent guy who was invested in the company. It was not an MBO transaction. It was selling for 9. He'd gotten 23 or 24. On a superficial analysis, this was a pretty good deal. if you're starting from fundamentals, you should say this was a business judgment case.
And for almost 3 years, the case continued as an appraisal case, with no suggestion of liability for breach of fiduciary duty.
The appraisal petition filed in March 1983, the fraud case filed in January 1986. And it was the discovery that changed the nature of it. This was before you joined the firm. But so from your standpoint, and then Art, from what you know, what happened? You have a plain old appraisal case going, doing a lot of discovery, but...
So there were 3 depositions that I think mattered. One was Fred Sullivan's deposition, in which facts that Arthur's client thought led to conclusions of insider trading, and a fee originally scheduled to come from McAndrews, but which at the very late in the deal was changed to come from Technicolor. So that was one. I think both of those facts, I'm now dredging up my memory, I think both of those facts were disclosed in the proxy statement. But I think Gary appeared excited when he got the testimony about that. The second one was Mort Cameron, the CEO. That was not so much exciting to Gary because there was some self-interest. In fact, Cameron's interest aligned very well, and with the shareholders, he had a lot of shares in Technicolor. But Cameron was not happy to be in the deposition and presented himself as, it's not going too far to say, an arrogant or patronizing witness, not a personality type that is going to mesh well with Gary, who could on his own be arrogant or patronizing from time to time.
Well, yeah, we see in the Cinerama briefs mentioned that Cameron would have rather been swimming, or...
He did at one point during the deposition say, I think Gary said, is there some problem, Mr. Cameron? And he said, on the whole, I'd rather be swimming. He also at one point said that truth is transitory, which was prominently featured.
It was in every one of our briefs.
I think it was, in fact, it was a frontispiece on one of the briefs, I think. Anyway, but I don't think, and Arthur can correct me, but I don't think the liability case would have been filed without the third deposition, which was the last director taken, Charles Simone. And it was one of the worst experiences of my professional life.
The story of the deposition of Charles Simone, one of Technicolor's directors, is central to how the Technicolor case mushroomed into Delaware's version of Jarndyce and Jarndyce, and Tom Allingham recounted it in painful detail.
I think it was taken in December of 1985. I had been told by several partners that I was on track to be made partner when Skadden makes partners on April Fool's Day, which is, I'm sure, symbolic in some way, but everything is fine. And so I'm defending these director depositions and thinking to myself, well, you can't screw that up. It's an appraisal case. But the last deposition was Charles Simone, so I called him and said, I'd like to come and prepare you for your deposition. And he said, no, I don't think that would be a good idea. And I said, well, you know, I could let you know what the other directors have been asked and give you a sense of how the process goes. And he said, no, thank you. I thought, okay. So at the time, Gary's offices, he shared offices with his sister, who I think was a designer or something like that. And the offices were in a beautiful old New York department store. I think it was Bergdorf's, but a beautiful old building. But the conference room in their office was a tall, cylindrical room that I've always referred to when I describe it as a missile silo. You walk in, and there was a circular stone table, and everything echoed because it was circular. So I was sitting there by myself, thinking, I just gotta get through this one, and then I'll turn to something else. And the door opened, and Gary walked in with Charles Simone, which I thought was not a good sign for me. And the first question was, do you recall the events of October 29th, 1982, which was the day of the board meeting. And Simone said, "Yes, I do, and I have a statement that I would like to read into the record." And I thought, well, this is not going as well as I had hoped. So he then read a statement into the record that described the board meeting in terms that were stunning. He said the entire transaction was a shock to every person in the room, that he had protested that he knew lots of people who would like to buy Technicolor, that he had been told to sit down and shut up, that he didn't know half the people in the room, that no one introduced themselves to him, that all of a sudden, after he was told to sit down and shut up, someone he didn't know who called for a vote, and everyone raised their hands and said, "Yes, except I, Charles Simone, said I oppose this transaction," at which point the doors at the end of the room burst open and Perlman walked into the room looking like a mafia chieftain or something, I don't know, and said, "We have won," with his hands in the air, we have won, and to celebrate this great victory, I invite you all to lunch at Le Cirque." So Gary, and this took quite a while, I mean, it was long, big legal pad. So Gary said, "No further questions." So I said, "Well, it's getting on toward 11 o'clock, why don't we break for lunch?" And ran across the city of New York and called Steve Rothschild, who had not been involved in the case for a couple of years, and said, "You're not going to believe this, here's what happened, what should I do?" And there's a little pause, and then he said, "I think you should cross-examine." So I ran back across to Bergdorf and went back to the missile silo and cross-examined Simone. And it turned out that there was a lot to cross-examine him about. The minutes of the October 29 meeting recorded that he had voted for the transaction. The minutes of the next meeting recorded that he had voted to approve the minutes of the October 29 meeting. He testified that he had reviewed the proxy statement and saw that it was a unanimous vote, but he had decided he was going to bring that up at the shareholder meeting, not correct the proxy, a lot of things. And then he also testified about some stuff that was a little crazier, like he, either off the record or on the record, I can't remember, but I think it was on the record. He testified that he had been awarded the French Legion of Honor Medal for helping to end the war in Vietnam. He had a lot of documents with him as he prepared his written statement, which he would not give to me. And when we concluded the first session of the deposition, I said to Gary, he's got to give me these documents, because this is a written statement that he just read into the record. And Gary called me the next day and said, "Okay, you can have a new deposition of Charles, but it has to be at his house in Cold Spring Harbor on Long Island." So we all trooped up to Cold Spring Harbor, and the great story about that deposition was that we got there at, 10 o'clock in the morning, and the door opened. A beautiful, gracious, Simone was, I think, 80, but his wife opened the door and said, "Please come in, welcome to our home." We sat down at I still remember this beautiful Chippendale dining room table. And Mrs. Simone said, would anyone like some coffee, tea, or a Bloody Mary?" And one of the lawyers, who shall remain nameless, said, I'd like a Bloody Mary, and keep them coming.
And with that remarkable turn of events, Charles Simone's testimony turned a relatively small stakes appraisal case into a lawsuit that would last almost 20 more years, and importantly defined the law of fiduciary duty.
We thought there was a real legitimate issue here about whether or not Charles voted against it. And the reason that was so important, and it's laid out in the opinions, but the reason it's so important was there was a supermajority provision in the Technicolor charter that required, as I recall, a 2/3 vote for a merger if it was unanimously approved by the board. If it was not unanimously approved, there was an even super majority, a 90% requirement. And even with the lock shares that were the company agreed to sell to Perlman, and the directors agreed to sell their shares to Perlman, even with all those shares, he only got about 89% of the shares. And so if in fact Charlie Simone voted against, under the Technicolor charter, the transaction was void because they didn't get the 90% that would have been required in the situation where the board was not unanimous. So it was a critical fact, and we believe Charlie.
Cinerama's lawyers also felt that the discovery revealed other flaws in the merger and the stockholder vote, involving Technicolor's CEO Mort Kammerman and its president, Art Ryan.
When you coupled that with sort of the testimony with regard to, Mort Kammerman's testimony, and he didn't remember anything, but what we did get out of all the other discovery was that he negotiated the price. He did it on his own. He didn't have any input from Goldman Sachs at the time. It was, he asked for 25 when Ron said 20, so without any reference to sort of any sort of he didn't ask the banker. He didn't have a banker yet. He didn't get a banker to go in and tell him, here's where we should end up, sort of a thing. When you couple that and a lot of other evidence, we really thought we had a good liability case, even if we didn't succeed on the void ab initio argument, which was also Tom mentioned the depositions. The other deposition I would add that we thought was pretty important was Art Ryan. Because we really thought Art Ryan's testimony really bolstered a lot of what we were saying about Kammerman being sort of difficult and running the show and not letting anybody, just having had it was his way or the highway sort of a thing. And there was a huge rift between Ryan and Kammerman. So Ryan's testimony was very helpful. We also thought the testimony from Ryan really demonstrated that there really was, he really had an interest that was undisclosed in the proxy with regard to information he was getting from the back channel that would lead him to think he had a chance of running Technicolor after the fact, which he did.
And self-interest wasn't the only arrow in Cinerama's quiver. With some reservations, it vigorously drew on the recent precedent in Smith versus Van Gorkum to make a case that Technicolor's directors breached their duty of care.
So a year later, was there a conscious effort, do you think, to pattern this in a Van Gorkum sort of way for the court? The fiduciary action?
I think it's probably fair to say we compared the case to Van Gorkum, and we believed that this case was, the facts were a stronger case than Van Gorkum. So we had that roadmap. And it sort of helped sort of us outline sort of where we wanted to go. But I mean, the facts were the facts, right? So we had directors who came to a meeting not knowing what it was about. We had Mort Kammerman negotiating price before talking to anybody else. We had Sullivan conducting insider trading as soon as he knew, first time he met with Perlman about a potential transaction. We had Sullivan trying to angle to get sort of a finder's fee. At least that's how we saw it. There were enough facts there to, and we had a meeting that took place in 2 hours. The company wasn't shopped. The legal advisor said he thought he would like to see it chopped, and it wasn't. We had Goldman Sachs prepared LBO analyses at a number that was higher than the $23. And Kammerman didn't want to do an LBO and just tamped that down from our perspective. So we had a lot of those facts. Some of those facts were similar to the Van Gorkum situation. I will tell you that we were all concerned. Although Van Gorkum, in a way, sort of gave us a roadmap, it also gave us a lot of pause. Because what happened with Van Gorkum, 102B7, and a lot of people were really, really concerned after Van Gorkum. That was the first time where the court had imposed liability on directors, and there was this hue and cry in Delaware. Even as a young associate, I was feeling that.
Imposed liability on non-self-interested directors.
Right. And so our fear was that even though we had what we thought was a case that was as good as, if not better than, TransUnion, Van Gorkum, the fear was going to be the court was going to say, we can't do this again so soon. And so no matter how good our case was, we feared that there was going to be this real reluctance to do this again, because there was such a negative reaction around the country from that decision, which again ultimately led to the 102B7 statutory provision.
One of the oddities of the Technicolor fiduciary duty case is that it was brought solely on behalf of Cinerama, which, at least theoretically, made the case easier to settle than a case brought on behalf of the class of all Technicolor minority stockholders.
And this is hopefully near the end of the questions before you appeared on the scene. Why wasn't the fraud action filed as a class action? Today we would expect a merger challenge like that to be a class action.
Yeah, I don't know why it wasn't originally. I know there was an effort to find a class action plaintiff, someone. The reason that I know the reason why we didn't file as a class action on behalf of our folks. We thought because we had filed an appraisal action, we would not be deemed an adequate class representative. And we thought we weren't going to take the chance of getting kicked out on that basis. We did look, as a young associate, I remember having this conversation with Gary and Peter. There was another lawyer in town, who I won't mention, but another firm in town that we talked to about trying to find someone. They thought they might have someone. We wanted to find someone who had been a stockholder but didn't seek appraisal, and didn't end up coming up with a plaintiff. I don't know how much effort was put into it, but I know that it was discussed, and I know that we talked to somebody here. Did anyone reach out to the sort of the big players? I don't know the answer to that, but there was discussion about it. But that's why we didn't choose to bring in as a class action on behalf of the people we already represented.
From our perspective, it was interesting. It seemed to us that the threat of a class action was much better for Arthur's client than a class action, because once a class action was filed, it would be much harder to settle individually with Cinerama. And so the danger from our perspective was that some class action would get filed, which would make it impossible to settle with Cinerama and would open us up to the very real possibility of having to pay a premium to everybody.
Of course, the case never did settle. And after the first of 6 decisions by the Delaware Supreme Court, ruling that the case could proceed simultaneously as an appraisal case and a breach of fiduciary duty case, the case went to trial in October of 1989 for 47 days, a record for the Court of Chancery that still stands.
So why was the trial 47 days long?
Undisciplined novice counsel on the Technicolor side. I think, actually, I think in a nicer way, I think that is, look, most of us didn't try cases in those days. It was a very unusual occurrence for trials to occur at all in Chancery, I think. And I don't know about Arthur, but it was my first. When I started at Morris Nichols, I did a lot of personal injury work my first year, and I did a bunch of trials, but they were nothing like this.
Right.
And I don't think I had tried a case. I had tried one case after that, so that was, this was 11 years after I graduated from law school. So I had not tried very many cases. I don't think Gary had tried very many cases, but I don't know. And the Chancellor was not, I don't believe, experienced in trying cases. So we all came into it, this is all, again, just my opinion, but we came into it with the Chancery Court's customer service mindset. We'll do whatever the parties and the lawyers think need to be done, and we'll get it done right, and we'll do a great job. And I think Bill Allen was the epitome of that kind of a model of, look, I'm not gonna brook any nonsense, but if I think that you're sincerely and in good faith asking for something, I'll try to give it to you. And from our perspective, the case had been fought very, very hard and fought on the facts very, very hard, and there were a lot of issues and 2 separate actions being tried at the same time with at least 6, maybe 7 experts with some very lengthy the Torkelson cross-examination at trial took, I don't even remember, 3 or 4 days.
I was going to say a week, yeah.
A very long time, and it was because there was, you're cross-examining on the nature of multivariate regressions. You're cross-examining on, I don't remember anymore, but all kinds of econometric models that none of us really had known anything about until this report came in. So I was trying to educate the Chancellor. The Chancellor was trying to absorb what was going on, and he was disinclined to cut us short.
It's funny nowadays when you have a new trial and you're trying to get a schedule, and one of the first things you do is you get the scheduling order, and the court puts in the day the trial's going to start, what time, and how many days you get. And it's usually, if you get 5, you're lucky.
Right.
Maybe you get 2 weeks if you're really, really lucky, if you get the right judge. I have not, in preparation for this, I didn't go back and look, but I'm guessing that the pretrial order, or not the pretrial, there was never any schedule in place that said how long the trial was going to be. I'm guessing it was open-ended.
The capacious trial included many witnesses, some persuasive, some not so much.
And both of you mentioned Meredith Brown in positive terms, and he does show up throughout the opinion, some block quotes of his testimony. Meredith Brown came in. He was a depositions. He was the deal lawyer for Technicolor. And again, at the time, he was writing on a slate that had not yet been written, because this was before all the big cases were decided. In your views, how did he handle the process, which admittedly was not what we normally see today? But what about Meredith Brown?
Well, two things. I thought that one of the strongest points during the trial for our side was Meredith Brown's testimony. He was eloquent about the state of the law as eminent practitioners like he was understood it at the time of the board meeting, at the time of the deal. And he said, I don't think that the fundamental nature of the duties of a board of directors have changed, but case law has fleshed it out. Revlon says that except in unusual circumstances, if you're selling the company, you should shop around. That was not, in Meredith's view, the law at the time. And he said, I advised the board that they needed to be fully informed about the value of the company, but I told them that they did not need to shop the company if they felt otherwise well informed. And he explained why he thought that had been the law and why that was the understanding of the corporate M&A bar at the time, and he was very strong about that. Now, having said that, he was not retained very far in advance of the board meeting. This deal was put together quite quickly, and quite quickly relative to what we would think of now. So some of the flaws in the process that were articulated by the court were not aspects of the process that Meredith Brown had anything to do with.
He was a good witness, terrific witness for your side, no question about it. He was pressing Mort Kammerman to shop the company. He wanted Mort Kammerman to shop the company. But as Tom said, ultimately he said it's up to the board. If the board has enough, feels that it has enough information, it can proceed, and they did. But it's clear from his notes, he had a notepad. I remember that was a discovery thing. We got the original, it was like under cover of darkness one night. I think Gary met you, or Peter met you out on the street one night, got the original copy of the. So and that was clear. He was pressing Kammerman to shop the company, but Kammerman didn't want to shop the company, and it was Kammerman's way. I thought, I agree that from your perspective, from your side, Meredith Brown was probably your best witness. I thought, at the time, Gary's cross of Kammerman was great and demonstrated that Kammerman was a terrible witness, I thought, because all of a sudden he had all this information, this knowledge that he didn't have. He had none in his depositions, and he did come across as arrogant. And so I thought that went well.
Cinerama's main valuation witness, however, didn't fare so well either.
When we got the expert report, which it was the damage calculation for the fraud case, and it was the appraisal report, basically. I mean, they didn't characterize it that way, but that's what it was. I thought it was possibly the best gift we could have gotten. And there were three reasons for that. One was $62.75 versus a $9 to $11 price. It was just, for a public company, was just off the charts. The second and equally important part of it was that that number came from an elaborate statistical econometric model with multiple, multivariate regressions and all kinds of very, very complicated stuff that was unnecessary. I mean, if you wanted to do a DCF, you could do a DCF. You could do it using the company's projections. And John Torkelson, who was the Cinerama expert, didn't do that. He constructed his own set of projections that flowed from this black box. The third piece of it, which was also important, was that critical inputs to the black box came from two industry experts that Cinerama hired, both of whom, well, one of them had testified before Congress a month before the deal, directly contrary to what he said in his testimony, and we had the congressional testimony. And the other expert, a guy from Variety magazine, he was well-regarded industry expert, had contributed a chapter to a book that was directly contrary to what he said to generate the Torkelson input. And so, we were looking at this 62.75 number, looking at it relative to 9 to 11, looking at it relative to the extraordinarily complicated model that had generated it, and then thinking about the cross-examinations of those two industry experts that I was sure even I could do well. We thought this is a home run. And you think about cases, I think I said earlier, I try to think about cases organically. If you can get the court to doubt some really big fact from the other side, then you're a long way there toward getting him to believe what you want him to believe.
As Technicolor's counsel surmised, Cinerama's aggressive valuation contention, $62.75 per share, for stock that had traded below $10 per share shortly before the deal, backfired, at least with Chancellor Allen.
And thinking again about the Cede Technicolor saga, and I know we could be here all evening if we went into it in more detail, but having spoken to some of the attorneys involved on the plaintiff's side, did you feel that by coming in at such a high value, $60, $70 per share, that they lost credibility with you, or was it just a function, as you said, of when you do discounted cash flow analyses and you move a discount rate, well, you can get a range as wide as Texas, as a judge once said?
Judges in Delaware, they know the areas, and unless, if there's no problem with the market, in Technicolor there was an active market in the shares, nobody has to believe in the efficient market hypothesis to nevertheless believe that unless there's some unusual explanation, of course any plaintiff's lawyer will find, oh, my case is usual, that is 100% wrong is one thing. That the price of $10 a share should be $20, maybe something the market didn't know, but that the price of $10 a share in an actually traded market should really be $70 is almost incredible. I mean, there could be a fact that there was actually uranium underneath the plant or something like that. But generally, what they do in those cases is the plaintiffs think they're creating a bargaining range. So they go as high as they can, think the court will slice the baby.
Cinerama was claiming the fair price of Technicolor was somewhere in the $62.75 range.
Right.
How did that affect as you marched toward trial?
I think it had a significant negative impact on the way the court assessed our case. I think that looking back on it, when you look at a public company, it's one thing to say, this company's undervalued by 20%. It's another thing to say it's undervalued by 300%. And I think
600%.
Nevertheless, Cinerama did have a story to tell about why the merger price of $23 per share significantly undervalued Technicolor. That story rested in no small part on the fact that Ron Perlman and McAndrews and Forbes, having bought Technicolor in 1983 for around $105 million, sold it about 5 years later, before the trial started, for about $780 million. A big issue then was whether to look at Technicolor as it existed before its acquisition in 1983 under Mort Kammerman's leadership, or as what it became after the acquisition under Ron Perlman's leadership. Mr. Perlman felt that the right approach was to look at the company as it was when he bought it, and not what it became.
I think the concept of looking backwards rather than forwards, as we found ourselves in valuing the price that we were going to pay. The video processing unit became a very, very profitable part of the business, which nobody had any clue of. A lot of the focus was on how that business developed years later, and I think that's the wrong way to look at a transaction. You got to look at it from the moment that you're making the decision to buy and what it looks like, and with the knowledge that's available, and nobody had any idea what home entertainment was going to be.
Even worse for Cinerama, testimony from one of its industry experts about the future of video processing called into question the aggressive forecasts it presented in support of its valuation contention.
From the Technicolor side, was there a lot of worry about the Carlton sale and the effect of the $780 million being out there?
The answer is sure. I mean, it was a hugely different company in that a lot of assets had been sold, and either a home run or a black hole business, 1 Hour Photo, had been disposed of. But the single biggest driver of that huge price was video cassette duplicating, which had exploded like a neutron bomb, and in a way that not even Steve Roberts, the industry expert who...
We made that argument. We said that was happening, and I think Technicolor's argument, you had a couple of arguments, one of which was there was no evidence to support it, and Roberts' testimony in Congress suggested otherwise. One of the other arguments was that it could have been video disc, and that might have been taken off because that was sort of around the same time frame, and we all know video disc went nowhere. But we're in an appraisal, again, you're putting on blinders, and so we felt really strongly about video. By the time we got to trial, we knew what had happened with video, but you're trying to put yourself in the position that you were years before, and
And the congressional testimony did not suggest that something different might happen. The guy who testified that video cassette duplicating was going to explode testified before Congress that the rental market was a ravaging steamroller threatening to eradicate video duplicating businesses. And his first explanation for that at trial was, well, I wasn't under oath, which the Chancellor did not
appreciate.
Did not get excited about.
As he explained earlier, Chancellor Allen was decidedly unexcited about Cinerama's valuation contention. In his October 1990 appraisal opinion, he concluded that the fair value of Technicolor stock at the time of the 1983 acquisition was $21.60 per share, even less than the $23 merger price. That valuation conclusion was critical to the Chancellor's subsequent decision in June of 1991 to reject Cinerama's parallel claims of breach of fiduciary duty, a decision that disappointed but didn't surprise Cinerama's lawyers.
So, Chancellor Allen's 1991 fiduciary opinion comes out. What's your reaction? I mean, you appealed, but did you think the case is over? How did you?
He decided the appraisal first.
Right.
So once the appraisal decision came out, we waited it was months. But we were waiting for the other shoe to drop. We knew that when he found 21, his price was 21 and some change.
2160, I think.
Yeah, we knew then that he wasn't going to find liability. So that was not a surprise. That didn't surprise at all. We were disappointed, but we wanted to get that decision so we could appeal them both. We knew we were going to lose. So we weren't at all surprised. We were surprised I don't know if we were so much surprised as we were disappointed in the fair value. We really didn't see how you could get that company, if you valued the Perlman plan, we didn't see how you could get to that number. But he didn't value the Perlman plan in his appraisal. He
Correct.
valued the Cameraman plan. We thought we were right on value because under the statute says you value the company on the date of the merger. We thought this is really pretty clear, and we thought you have to at least give us the benefit of the planned asset divestitures that Perlman is going to the bank and said he's going to do. So we thought we would get that, and so we were really disappointed when the number came in where it did. But it came in where it did largely because we thought he got the law wrong.
So the stage was set for oral argument in the second and arguably most important appeal to the Delaware Supreme Court.
Cinerama appeals. What was the oral argument like?
Well, Gary made it from our side, so I'll let Gary speak to the argument. I had a reaction. If that's go ahead and talk.
Well, I'll tell you two things. One was it was the shortest of my prepared remarks I ever got through. I said, Your Honor, I'm Tom Allingham, and with me at counsel table is, and Justice Moore interrupted me and said, you wrote an article about our opinion in Weinberger, which has been proved to be wrong. Isn't that correct? And I never got back to my argument that I'd written out. Not surprisingly, our evaluation of the argument was that we were going to lose. It was very hostile to our side, led by Justice Moore and Justice Horsey, the authors of Weinberger on Justice Moore's part and Van Gorkum on Justice Horsey's part. And they seemed to have some real irritation or hostility with the Chancellor's treatment of those cases in the opinion. So we were pretty confident that we were heading back to the Chancery Court, but I have to say I did not expect a lot of what came out in the Supreme Court's opinion.
I like to think that they were reacting to sort of a lot of the facts that even the Chancellor found with regard to directors not knowing about beforehand, and cameramen negotiating the price and those kinds of things, which we made, which we played up on. And I think that was the kind of thing that we sort of envisioned Justice Moore being offended by, and I think it had that sort of result.
So you weren't surprised. Well, were either of you surprised when the Supreme Court's opinion came out?
I don't think you guys were surprised, were you? We weren't.
We were cautiously optimistic. We really thought the argument went well.
And Cinerama's counsel was right to be optimistic. The Supreme Court's 1993 opinion, known as Cede 2, caustically criticized Chancellor Allen's judgment and found that Technicolor's directors were grossly negligent, based on findings that the Chancellor had assumed solely for sake of argument, a move that rankled Technicolor's lawyers and the Chancellor himself.
And we weren't surprised at the outcome, but we were furious is not too strong a word at the, and I don't like to say this, but I'll say it since we're in an archive situation. I thought that the conversion of assumed facts into findings of fact by the Chancellor was intellectually dishonest, and I thought it was the underpinning of a lot of what happened thereafter, including Arthur's, I think, rightful optimism about the ultimate resolution of the case. It made it impossible for that case to resolve. It was not, the Chancellor did not make those findings, and to adopt findings that aren't made, I thought was wrong.
Talking about the Supreme Court and sometimes differing from your views, I was reminded that there was a moment in Cede Technicolor when you said in one of your opinions something along the lines of, I'll assume arguendo gross negligence, but nevertheless, and then the Supreme Court said the Court of Chancery assumed gross negligence.
No. The Supreme Court said found.
Found, I'm sorry.
Yeah, just intellectual dishonesty. I can't say, I can't put more of a, I mean, maybe you can't read. That was, again, Justice Horsey, I think, who wrote that. I mean, there's a discipline in the trial court or in the intermediate appeal court that any Supreme Court doesn't have. That is, they don't get reviewed. And for the strong judge, the intellectually strong judge, she will not have to play games with the record. But for some, they write what they want in order to justify their opinions.
The Delaware Supreme Court's opinion also controversially criticized Chancellor Allen's reliance on the case of Barnes versus Andrews for the proposition that a plaintiff who proves negligence still has to prove that the negligence resulted in some harm to the plaintiff.
And the one thing that the Chancellor did do that the Supreme Court criticized was using the Barnes case. And the quote from the Supreme Court is criticism for finding, quote, authority for its requirement of proof of injury in a 70-year-old decision that none of the parties had relied on or felt pertinent. So neither of you, I guess, had cited it, but...
I certainly thought it was pertinent, but we cited lots of cases that were like it, and it's an opinion from learned hand who's hardly chopped liver, and I don't think that it's unusual for a trial court to send a clerk off to find support for a proposition that the court thinks is relevant to his analysis. So I thought the criticism was, again, unfair, and it was one of the things that led me to think that there was animosity between the two courts, and that it was going to be part of my job on remand to try to tamp that down so that I got as much of a plain, I wanted to win, obviously, on remand, but so that the terms and language of the remand opinion were as plain vanilla as possible. Yet another failure on my part.
I always thought what the Supreme Court was saying with that was, though, that you shouldn't have gone to New York law. This was a Delaware law issue. We don't defer to New York. This is Delaware, and that's a very different rule applied in the traditional negligence context, and it really has no application in a corporate fiduciary situation. So I never really thought they were being so critical of the fact that he found a case that we didn't cite, so much as that they were being critical of him going to New York law to begin with and finding something that was so, I think, so inconsistent with Delaware law, and then basically saying, okay, that case says that now that you've proven that these people were asleep at the switch, you still now have to go on and you have the burden of proving damage and your harm, and I think that was what they were saying. That's just not consistent with Delaware law. Whether it was or wasn't, they didn't think you should be deferring to New York on that. That's how I read it, but I do, when you look at it in it, when you read it, it does seem to suggest that they were offended by him finding something, relying on something nobody cited. I don't think that's what they meant.
In Cede 2, the Delaware Supreme Court also criticized the parties for not addressing the effect of Section 144 of the Delaware General Corporation Law, and criticized Chancellor Allen for using a reasonable person standard for determining the materiality of a given director's self-interest in a challenged corporate transaction. Yet the lawyers for both Cinerama and Technicolor felt that these criticisms were either inconsequential or irrelevant.
Much of the Supreme Court's opinion deals with the reasonable person standard and whether that was, well, right or wrong. But that didn't really have much of an effect in the case going forward, did it?
I don't think it did, no. I don't think it
And
did.
I don't think the findings of self-interest would have been changed
No.
by the,
No.
the, whatever it is, the subjective standard. I don't think it would have mattered.
Yeah, I think would come out, from our perspective, we would come out the same way, whichever standard you would apply, we believe we would have demonstrated that the directors that we thought were being disloyal were disloyal.
We spent probably too much time at trial or in the briefs arguing about that standard. We were arguing reasonable director standard just because we thought the alternative was just cumbersome and as a policy matter unwieldy, but it wouldn't have mattered.
And the Supreme Court took the parties and the Chancellor to task for not addressing Section 144 or the requirement of director unanimity, but neither of those really played a part in your views.
Well, no, an interested director can vote as long as the interest is disclosed. So we didn't see, and I don't think that Gary and Arthur saw any impact of the self-interest issue on the unanimity issue. And once the Simone issue was resolved, the unanimity charter provision didn't really apply.
Right.
And Section 144 didn't apply. The parties didn't brief it, and the Chancellor didn't address it because on its face, it wasn't applicable.
What the 1993 CD2 opinion did, however, was leave the litigants with very different views about how the case would come out on remand. So, ensuing settlement talks between Barry Schwartz for McAndrews and Forbes and Jim Cotter for Cinerama were probably doomed from the start.
So what happened? Well, obviously there was a remand. What were your approaches to the remand?
Well, I'll tell you, we were afraid that Tom was going to go in and want to introduce additional evidence, have new evidence to try to meet his burden of demonstrating the transaction was entirely fair. Because we thought under this record, when you've got these directors, you've got now a finding from the Supreme Court that these directors breached their duty of care. You've got a finding that Cameraman sort of set the price on his own. You've got a finding that some of these directors didn't know. All the things that went to the sort of the do care thing, and you've got a mooted appraisal. So you don't have a number without somebody coming and testifying about what, entire fairness, what the number should be. We thought we were very confident. We didn't think that the defendants could establish entire fairness. The other thing was, we understood the Chancellor had said, we argued all along that there was a lockup here, and when you read the post-trial decision, our interpretation was Chancellor Allen was saying it was a structural lockup, and we thought, with that fact, and there was a no shop, they didn't shop it, they had no fiduciary out. We thought this was we thought we were going to win. And I think that was the context in which Barry Schwartz and Jim Cotter got together for lunch to have a settlement conversation. And I don't know how that came about. I think you may have been in.
I think I called Gary and said the parties my guys wanted to have a meeting. But going into the meeting, I was asked, what do you think? I mean, is there a path to the end zone? And I said, I think there is. I do not think that the court will ignore the appraisal valuations. I think we can still reference them. And I still think that, I don't think they can back off the 6275 number because it's out there now, and they, I think they're wedded to it. And so I think all the credibility issues that I thought drove the first opinion, I think are going to be in play in the second opinion. I'm not telling you this is an easy task, but I don't think that we are, fighting a losing battle here. And I think from the other side, Jim Cotter was hearing something very different from that. And so the report I got back was that they weren't even close. They weren't even in the same zip code.
Yeah, my recollection of what I heard at the time was, I think it was Barry Schwartz that went out and met with Jim Cotter.
That's right.
And the message that I heard was Barry said to Jim, "You think you've won this, but you haven't. We'll give you $1."
$1.
Yeah,
A dollar over the deal.
A dollar
A dollar
over
over
the
the
deal
deal
price. And I think what I heard was Cotter saying something along the lines of, "Well, then you're going to pay for lunch." That was the last of the settlement discussions, I believe.
The remand to the Court of Chancery to determine if the Technicolor acquisitions satisfied the stringent entire fairness standard of judicial review posed a novel issue.
Until CD2, until what I think of as Technicolor 2, the question of whether the business judgment rule or entire fairness applied was, I think, pretty widely regarded as case dispositive. If you got entire fairness, you were going to lose. And so CD2 was the first, and the appeal of the remand was the first case that I know of where the parties engaged on the question of whether a case could be, a deal could be entirely fair in the face of a flawed process. That is to say, in the balance of the question of fair price and fair dealing, whether you could have a very high quantum of one and that would solve a deficiency in the other. And I think that the court acknowledged that that is possible and that that changed the way, certainly at least in my litigation career, it changed the way I thought about deal litigation and about whether I'd rather try a case or, settle a case. I think it offered defendants some leverage that didn't exist before.
As it turned out, the ray of hope that Technicolor's lawyer saw turned out to be a blaze of glory, with Chancellor Allen deciding in 1994 that the transaction satisfied the entire fairness standard, and the Delaware Supreme Court affirming that ruling in CD3 less than a year later. Developments that stunned Cinerama.
So Chancellor Allen finds it entirely fair. That was your hope, and you never thought that would be a possibility.
We were stunned, to put it mildly. We were. At that point, the only fear we had was that Chancellor Allen was just so wedded to the other side's case that he was going to ignore all reason. But we were very confident that when he applied, the law, we were going to win, and then we lost. We were just stunned.
And how about, so then you appeal again? And anything different? That was the appeal you said where there were no questions.
My recollection is there was not a single
There were no
question.
questions. That's correct. We went through, we had whatever we had. I think we had 20 minutes each. They were reasonably long arguments, and I went through my entire argument, and I was done in 18 minutes. And I said thanks. Not a question from the bench. I've never had that happen before or since. After having been eviscerated the first time around.
But then the Supreme Court affirms.
And obviously we never completely, I still can't understand how that could be. The Supreme Court did certain things in that opinion that so the way we read the Chancellor's opinion on remand was he said, well, remember I said there was a structural lockup? What I really meant was it was locked up because the price was so good. And so that was inconsistent with, and we really were optimistic that the Supreme Court would say, no, that's not, it was a lockup, and there was no, that, the $23 or the $21.60, whatever the number was he found is no longer relevant. We thought we didn't think that they could affirm it, but they did.
Were you more surprised by the Chancery opinion on remand or the Supreme Court affirmance?
We were as disappointed in each. I don't know if we were more surprised.
Because Alan, you at least had a sense.
Probably more surprised in the Supreme Court, because we really thought from the tone of Justice Horsey's opinion in CD2 and the arguments, we really believed the arguments. So I guess we probably were more surprised by the Supreme Court, but again, equally disappointed.
Of course, the case continued as an appraisal case, just as it started out 12 years earlier. And it continued for over 10 years more. After 2 more Supreme Court reversals and a new trial on valuation, the Court of Chancery, now in the person of Chancellor William Chandler, returned in 2003 with a judgment of $21.98 per share, just pennies more than Chancellor Allen's original valuation. But in the sixth and final appeal in 2005, the Supreme Court again reversed, mandating use of a lower discount rate and a lower figure for corporate debt, and extending the duration of the very favorable rate of prejudgment interest of 10.32% compounded annually. Those mandated adjustments resulted in a valuation of $28.41 per share, a long, long way from the $62.75 that Cinerama argued for, but considerably higher than the merger price of $23 per share. Belatedly, then, the question arose: would that higher valuation have precluded a finding of entire fairness?
The one thing I would say, though, is I think the reason it would come out differently, in my view, today is I think in large part, ultimately, the Chancellor determined the transaction was entirely fair in reference to, or by reference to, the number he had found in the appraisal case, which had been mooted in an earlier appeal in the Supreme Court, and then we of course went back and had the appraisal. But he found entire fairness in large part by reference to his fair value determination, which ultimately was set aside. So I think if you actually tried them together today, given the fact that ultimately the fair value determination was something like $20 and change years later in the subsequent appraisal, I think that would dictate that the transaction would not survive entire fairness.
And you see the Chancellor's reliance on the deal. I mean, as you mentioned earlier, his reliance on the price that he found first, come through in all of his fiduciary opinions.
Yeah, that's always the thing that's always nagged at me, because when you go back and you read the decision on remand following Cede 2, and the Chancellor really does, in my opinion, find the transaction entirely fair in large part by reference to what he found to be, what he thought was a very fair price. And before that, the Supreme Court had said, because of what we're doing in Cede 2, the appraisal appeal, which we had appealed at the same time, was moot.
It was moot, right.
And then the Supreme Court then affirmed him on the entire fairness, and as a consequence, they said now the appeal's no longer moot. So then we had another, how many more years? Another 12 years of litigating on the appraisal, and ultimately the Supreme Court found the fair value to be significantly higher than the value that the Chancellor had found. So you really have to say, well, does that entire fairness finding on remand really withstand analysis, because a fundamental underpinning of that has now been knocked out? But that's really sort of an academic question, I think, at this stage.
It is an academic question, but it's an interesting one. I think that the ultimate finding of value, and we argued this in a motion to re-argue after the Supreme Court's last decision, I think that the Supreme Court's clear intent, Chancellor Chandler had found the value to be 21 something,
2160 or something.
30 or 60 or something. And I think that the Supreme Court intended to make a little tweak in the value and nudge it upward a little bit. I think they would have been shocked before the fact if they had learned that it bumped the value up 20%. It was a tweak to the cost of capital, I think, or something.
There was also the discount rate too, because I think the discount rate was determined to be law of the case, and that changed.
Yeah. But I don't think they thought it was going to be a big deal, and it turned out it was a significant deal. In fact, it pushed the valuation above the deal price. This is all conjecture. I don't
I was
really
going to
know
say this will not surprise you to hear me say I don't agree with it.
Different view.
But the question certainly became moot. After the sixth and final Delaware Supreme Court ruling, the case was resolved for good, after 22 years of litigation. Both sides saw at least some good news in the final result.
We never accepted that this was entirely fair, but obviously it was deemed to be so by the courts. I think we ultimately felt vindicated in the appraisal. So, I mean, I think it's one of those rare cases where both sides can see some vindication, can find vindication. Our client was thrilled with the ultimate award, thanks to the compound interest award, and vindicated that our number was, I mean, a big part of it, in the last dozen years, a big part of after the liability case was over, a big part of it was sort of principle. We were determined to establish that this was worth more than $23, notwithstanding the fact that we had argued $62.75. We truly believed it was worth substantially more than that and felt like we were vindicated there. But for a long time, it was hard to get over the finding the entire fairness in the transaction that we felt so, we were so committed to, we just felt was just not a fair transaction.
Well, we weren't 100% satisfied with the final decision and the judgment, but on balance, we proved entire fairness. So we proved that the transaction was entirely fair, which meant no director liability. That was a really big thing, and that was something that nobody had ever done before. So we felt very good about that. We had twice valued the company at below the deal price in appraisals, and we felt very good about that. We thought that the Supreme Court had just made a mistake, but that was just our guess, but that's what everybody on our side thought. So we thought, and it was 22 years of, it was 46 million of 52 or whatever in terms of interest, but it was 22 years that we were holding the $6 million. So, that's what interest is for, and although 10.32 was high, in some of the periods during that 22 years, it was probably low during other periods. So on balance, we thought it was a good result.
Even if each side saw some good news, it was striking and disappointing to Mr. Perlman that after 22 years of litigation and an estimated $20 million in legal fees and expenses, $46 million of the $52 million judgment was interest.
The other thing that was most bothersome was we kept winning the cases, the lower court cases, and then it was sent back by the Supreme Court to be reviewed again. And ultimately, the value that was determined to be the right price was less than we paid. But in Delaware, they had the ability to get interest from the moment that the offer became live until they got paid.
At a very attractive rate.
Very attractive rate.
Yeah.
So it became an investment vehicle, the court, rather than a determinant of fact or law or value. And I think that it is and was very unfair. So we ended up paying, 25, I'm making this up, 25 cents less than the offer price, but we paid $50 million in interest, which was just silly. And the plaintiffs knew that, and this started out, the plaintiffs started out as just wanting to roll from one year to the next, and said, would it be okay if we took our money and, so they started this action to justify that. And then they realized, hey, this is a pretty good investment vehicle, and that's not what the court should be.
More precisely, and as observed when we started this narrative, was the $1.1 million recovery over and above the merger price worth 22 years of litigation and $20 million in expenses? The question becomes particularly poignant when we learn about how close the case came to settling when it first began in 1983.
All I heard from Steve Rothschild that the case got within $200,000 of settling at a price level of order of magnitude $31 or $2 a share. So, you're talking about a 2 or 3% delta that would have gotten the case settled back in March or April of 1983. in a case that ultimately probably generated, gosh, I don't know, $20 million in fees, maybe
I'm
more.
sure. I'm sure.
Certainly an amount of fees that dwarfed the delta.
Not surprisingly, given the duration of the Technicolor litigation, most of the key players in the case you've heard about here have retired or passed away. Tom Allingham and Art Dent are both now retired. John Torkelson pleaded guilty in 2008 to perjury for concealing contingent fee agreements for serving as an expert witness. Charles Simone died in 1990, in the middle of the litigation. Morton Cameraman died in 2006. Meredith Brown died in 2018. Justice Andrew G.T. Moore II died in 2018. Justice Henry Horsey died in 2016. Chancellor William Allen died in 2019. Gary Greenberg died in 2008, a little more than 2 years after the Technicolor litigation ended. Like life, litigation is unpredictable. And there's hardly a better example of that than Cede versus Technicolor.